Very much. Any questions? You're good? Okay, going forward, let's see. Now we're going to hear from Mr. Zidney with the, there you are, with the Homeowners Association issues.
I printed up some things.
Okay, thank you very much.
Thank you.
Oh, okay, great. We'll get one to Senator Negron.
Thank you so much again, as many have said, to have a public meeting. I am a private citizen. I live in a homeowners association. In past years, I've been president of 2 condo associations and a member of a homeowners association. And for the good work of the legislator last year, I would call it a bumper year in improving HOA and legislation and the rules. But with all that progress, I'd like to report at least an issue that I've seen in my own case, and I've heard from others. I've consulted through the web with experts, and I think they agree. What this request is about today is today's HOA legislation is misleading because it reads as if it applies to all HOAs, but it doesn't. And the experts that I've consulted with have said, when you ask a question, do all Chapter 720 changes apply to my HOA? The answer is it depends, and the experts classify HOA legislations, Chapter 720, as either procedural, and those procedural changes do apply. But they also classify some as substantive, and those do not apply. And in the printed material that goes with these charts are quotes both from publications like the Condo and HOA Law Blog and from various communications, including some from me to experts. Another expert opinion, does a specific 720 change apply to now, first it was all, now a specific one, and there's at least one case in which an expert says that change is debatable and may actually have to go to the courts to decide. And finally, for those that live in a developer-controlled association, do they apply to a developer? And the statement that is made in the attachment is they cannot be retroactively applied. So the developer's rule stands unchanged, even though 720 may contradict the way the governing documents are. So I'm asking for something that is a little lower than legislative change. With each legislation, there's a very excellent bill analysis that is published by the staff, either on the Senate side or the House side, and I've read the analysis for what was HB 7119, and it was very complete, and there's a page that's a copy in the attachment. But it really needs to explain to the public, the constituents, does a specific provision affect all existing HOAs or only HOAs created in the future? Because from the correspondence that's in the attachment, those are 2 very different applications. And there could be some additional categories. I just listed a few. For example, when an amendment is made to a governing document, should that be controlled by the current legislation or by the legislation that existed on the date that the association was formed? So I need to let people much more expert understand and create that. And then there's even a bigger next step. Wouldn't it be great if there was a white paper produced by a state organization like OPAGA or whatever, in plain language for all stakeholders, both those who live in associations and I think very importantly those people who would be considering moving in an association, realtors, directors, constituents. For example, Debbie, I really enjoy receiving and reading your Mayfield minutes.
Thank you.
You reported on the legislation, but you didn't say whether or not everything in it applied to all HOAs. So if there was this easy-to-understand document, your office or you could tell your constituents that. And I wrote some other considerations, but I think I'll skip that right now.
Okay.
So on the last page, what I'm asking you to do now, please, if it's at all possible, is reissue the bill analysis for HB 7119 and identify what provisions apply to existing HOAs and what provisions would apply to future ones in the categories, at least I'm not expert in this area, but what experts have told me about. And I put a little flow chart at the end, which I'd have to have on a screen to explain. But on the right half, what I'm showing is procedural provisions. Some of them change the governing documents, but not all of them, because it is not mandated that a procedural change appear in the governing documents. So those apply to the HOA directors directly. And the current change to Chapter 720 requires directors to certify they have read the governing documents. But it is silent on whether they have read the legislation. And since their decisions come from two paths, one from their own governing documents, which may or may not have been changed over the years, and those that directly come from the legislation, I think that is one change that really is important, because it's sort of broken. If the director knows everything in his governing document and nothing about the legislation, he'll make terrible decisions. So that's my help, but particularly if there was some way to reissue a new 7119 bill analysis, that'd be tremendously helpful. And it would then be a startup for future use of this concept of what applies and what doesn't apply in future.
Just to, and I agree, homeowner association is a huge issue and it's very complex. The state actually does not regulate the homeowners associations like they do the condo associations.
Yes.
There's rules in place that as guidelines, but the big issue that we've had is that if you have an issue as a homeowner association, you call the state, they say, well, we don't regulate you, which to me was a big issue. Then why do we even have it in the Florida statute? So part of that House Bill 7119 that we did as a committee bill was to try to figure out a way how to start the regulation process. We have no idea how many homeowner associations we have out there. It's not like it's a condo association. You have homeowners associations that could only have 5 houses in it.
Right.
And you have them that are managed by the people that live in there. And then you have them that are managed by community homeowners associations. So what we were trying to do was first start with the community homeowners associations. That would make it easier because they are regulated. All the community homeowners association managers are regulated. So we put into law that if you are managed by that a community management association or a community management property management company, because they are regulated, we put specific things that they have to make sure that the homeowners association is abiding by on it.
I read that, and
that's what we were trying to do.
Well, that's a step, but
exactly. But we will. I'll get you, and I'm sure we need to tweak it. There's no doubt. It's in place now. We need to take a look and see how effective it's been. It took a lot just to get that done. I mean, there was a lot of resistance.
So I'm not proposing. That's why I'm not proposing a significant legislation.
Exactly.
I'm talking about a procedure within Tallahassee that when a bill analysis of HOA, maybe even condo legislation, that they inform the public as to which ones apply and which doesn't. In my longer write-up, I'm in a developer-controlled HOA for a decade and who knows longer.
Oh, yeah.
And I met with the board who was appointed by the developer and said, hey, how about electing one of these representatives that is specified in one of the changes? And the answer was, no, that change only applies to future HOAs.
That are governed by the community.
Well, but the opinion I've had from experts in the field that answer is wrong. Now, we as a bunch of residents could start having attorneys and spend time in court, but since the legislation comes from Tallahassee, it ought to say to this developer-appointed board whether or not it applies. I don't know why we at the low end of the spectrum would be having to define what the legislation means.
I agree, and we need to get that out more. We've tried to get that out through all the channels out there, but we'll get together. I'd love to have some specifics.
Well, the bill analysis would be a very simple and easy place, and if you read the bill analysis with 7119, the only thing a reasonable reader could come with is it applies to every single HOA, every single board, and every single member. That's what your analysis says, and it really is wrong. And I think you ought to correct, pardon me, before you correct the HOAs, I'm arguing you ought to correct Tallahassee.
Okay, we'll do that.
Thank you. And if you do reissue or decide not to, I'd appreciate an email as to what your decision
we'll get together. We'll set up an appointment so that we can spend more time in going through it and help you.
It's a great step forward, and I'm proposing one more.
Thank you very much. Okay. This is what's great.